You know, usually when we talk about a medical diagnosis, there is this expectation of absolute, unambiguous precision.
Right, it is treated almost like mechanical engineering.
Exactly. I mean, if you break your arm, you go to the hospital, they run an x-ray, and that machine produces this high contrast image with a jagged white line.
Yeah, a binary system.
Right. The doctor just points at the screen and says, well, there it is. The data is raw, it is unfiltered, and it is undeniable.
And humans find immense comfort in that level of visibility. We really like complex problems to be reduced to categorical truth that we can just see with our own eyes.
We do, but then you step into fields that do not have that mechanical clarity. You look at neurodevelopment or chronic autoimmune conditions, and suddenly that pristine x-ray machine is completely useless.
Oh yeah, you are looking at a diagnostic landscape that is incredibly murky.
Right, where symptoms overlap and the data is just open to massive interpretation.
Yeah.
Now, I want you to take that feeling of uncertainty and apply it to what we're diving into today.
It is a terrifying pivot, honestly.
It is. Imagine that diagnostic machine is not just struggling to find the truth, but it is actually actively inventing things. Imagine a machine that generates bones that do not exist, places them in a perfectly formatted medical report, and just hands it to you with utter, unshakable confidence.
Yeah, that is exactly where we are.
Welcome to the Data Genius Podcast. I am absolutely thrilled you are joining us today. You, the listener, are in for an incredibly timely, arguably vital journey. Today, we are setting our sights on the explosive evolution of artificial intelligence in the legal industry as we hit the year 2026.
And I have to say, the word explosive really isn't hyperbole here. We are witnessing this unprecedented expansion in both raw technological capability and, well, catastrophic professional liability.
Yeah, the ground under the legal profession is shifting way faster than the regulatory bodies can even pave it, which is exactly why we are doing this. What you are going to gain from this deep dive is a comprehensive roadmap.
A survival guide, really.
Truly. We are going to help you navigate the massive promises and the perilous pitfalls of legal AI. We're going to walk you through real-world court sanctions that are actively destroying careers right now.
And we will unpack the rapidly changing ethics rules across different states, too.
Yes, and we will give you a definitive buyer's guide to the software that is actually working right now, as opposed to, the software that just has the biggest venture capital marketing budget.
Because there is a lot of that out there.
Yeah.
Our core mission today is to cut through the immense hype and the equally immense fear that surrounds legal AI.
Right.
To do that, we have synthesized a massive stack of 2026 industry reports, federal court rulings, state bar ethics opinions, and some really deep technical software evaluations.
We want to distill these facts to provide you with a clear, actionable framework for how legal professionals can adopt AI safely, without losing their license or destroying their attorney-client privilege. Okay, let's unpack this.
Let's do it.
Because to understand where we actually are in 2026, we have to understand the fundamental paradigm shift that got us here. We are officially exiting the era of passive AI chatbots, where you just ask a screen a question, and entering the era of what the industry calls agentic AI.
That transition from passive to agentic, it is the defining technological leap of this year.
Right.
We have definitively moved away from the phase of exploration where lawyers were just sort of toying with ChatGPT to see what it could do into a phase of strict accountability.
And measurable return on investment.
Exactly. Firms are no longer asking if this stuff is cool. They're asking, does this increase our margin?
Which changes everything.
It does. And to put the scale of this into perspective, current expert forecast project that by the end of 2026, autonomous agents will handle 40% of routine legal tasks entirely without human prompts.
Wait, 40%?
40%.
Just to be clear for you listening, that means the software is executing tasks without a human being ever hitting the enter key to initiate it?
Right. It is completely autonomous.
Let's contrast that with the past, just to give a sense of scale on how fast this is moving. I mean, a few years ago, we were relying on what we can call layer 1 technology.
Yeah, basic rule-based process automation.
Which was basically just operational plumbing, right?
Exactly. We were talking about tools that automated routing client intakes, managing matter assignments based on workload, triggering approval chains.
Like setting up basic litigation calendar reminders.
Right. It was entirely pre-programmed. If X happens, do Y. It minimized administrative friction, certainly, but it left the entire cognitive and analytical burden squarely on the shoulders of the human attorney. The software did not think.
No, not at all. And then we saw the evolution into layer 2, which was the era of document assembly. And I remember this felt revolutionary at the time, but in hindsight, it was quite rigid.
Oh, it's essentially just a sophisticated mail merge. Layer 2, standardized drafting through template engines and variable substitutions. A lawyer would fill out a digital questionnaire, plug in the transaction-specific terms, names, dates, jurisdiction, purchase price, and the software would generate an initial draft of a contract or a motion.
But again, the substantive legal analysis, the actual judgment calls about which clauses protect the client's unique interests, that remained a purely human endeavor.
Exactly. The tool was just a very fast typewriter with a good memory.
Right. But now we're talking about autonomous agents, and the distinction here is absolutely vital.
It is the whole ballgame.
These agents bridge the gap between static data and independent action. They are not just sitting idle waiting for a lawyer to ask a question or fill out a form.
No, they are proactively checking incoming regulations.
Yeah, they are cross-referencing those new regulations against a company's internal policies.
They are drafting adjustments to vendor agreements on the fly.
And they are pushing alerts to attorneys about compliance risks before the human even knows there is a problem to look for. The ultimate goal for developers in 2026 is what the industry is calling the invisible agent.
The invisible agent concept is fascinating from a workflow perspective, really.
How so?
Well, the philosophy is that these tools should integrate so seamlessly into existing, deeply entrenched workflows, specifically things like Microsoft Word or Outlook, that lawyers hardly even notice they're interacting with an AI.
Oh, so they are not opening a separate browser tab to chat with a bot.
Exactly. The AI is embedded directly in the document margins, executing complex reasoning tasks in the background. And the driver behind this push for invisibility is purely economic. It is all about ROI.
Because the sheer novelty of generative AI has just evaporated.
Completely. Law firms and corporate in-house departments are demanding measurable efficiency gains to justify these massive software subscription costs.
And I was looking at the productivity numbers in our sources for this deep dive, and they are staggering. I mean, teams that have successfully integrated these autonomous agents are reporting a 50% decrease in the time it takes to review standard documents.
50%. Think about that.
And within the first year of deployment, they are seeing a 30% increase in overall operational efficiency. Plus, manual human errors in rote tasks like contract filing or data extraction are dropping by nearly 90% when the agents handle the initial pass.
Which is huge. I mean, if you're managing a lean in-house legal team at a mid-sized corporation, cutting your document review time in half isn't just a nice little perk.
No, it is transformative.
It is entirely transformative to your business model. It shifts the lawyer's daily focus away from manual data entry, endless scrolling, and rote review, and it allows them to allocate that mental energy to high-level strategy.
To complex negotiation and actual legal oversight.
Precisely.
But hold on, if we follow the logic here, if these tools are becoming invisible digital teammates that do all this heavy analytical lifting behind the scenes, aren't we essentially setting up a massive blind spot?
Yes. A massive one.
I mean, it feels like handing a scalpel to a surgical robot that hasn't been fully programmed with a map of the human nervous system, and then the human surgeon just looks away while it makes the first incision.
That is a great way to put it.
How do we know this invisible agent isn't completely botching a critical court filing while we are busy focusing on high-level strategy?
Well, that is the pivotal vulnerability of the current landscape. Assuming that a sophisticated piece of software actually possesses the judgment of a licensed professional is exactly how several very prominent attorneys have recently destroyed their careers.
Because the technology is brilliant at mimicry.
But it possesses zero actual comprehension.
Wow. Which leads us directly into the defining crisis of modern legal tech, the hallucination epidemic.
Yeah, the hallucination epidemic.
Because despite all the billions in venture capital funding, and despite the incredibly slick marketing campaigns promising flawless performance, these tools still fundamentally make things up.
They do. And we really need to understand the underlying mechanics of why that happens.
So to grasp the true scale of the problem, we have to look at this pivotal 2024 study conducted by the Stanford Institute for Human-Centered Artificial Intelligence.
Right, the HAI study.
Yeah. And they didn't just test free internet chatbots. They specifically tested premium, purpose-built legal AI tools. We were talking about enterprise-grade systems from industry titans like LexisNexis and Westlaw.
These are the tools where the vendors explicitly claimed the hallucination problem had been solved.
Exactly. They heavily marketed their use of RAG technology, retrieval augmented generation, as the silver bullet that made their AI hallucination-free.
And RAG is a brilliant concept in theory. I mean, to explain the mechanism simply, a standard large language model, or LLM, is essentially just a prediction engine.
It doesn't actually know facts.
Right. It just predicts which word is most statistically likely to follow the previous word, based on its training data.
Yeah.
It is like a world-class improvisational actor. It knows how to sound incredibly plausible, but it has absolutely no commitment to the truth.
So RAG was supposed to fix this by acting as a strict script for the actor?
Exactly. When you ask a RAG-enabled AI a legal question, it first searches a closed, trusted database of actual case law, retrieves the relevant documents, and then the AI is instructed to generate its answer based only on those retrieved documents.
So it forces the AI to take an open book test.
Yes.
But the Stanford study proved the open book test didn't stop the AI from cheating.
Not at all.
They found that even using these premium RG-enabled models pulling from verified legal databases, the AI still hallucinated in over 17% of the benchmarking queries.
Think about the gravity of that. Roughly 1 in 6 queries returned inaccurate information on the most expensive, highly specialized, heavily engineered legal tech on the market.
1 in 6. And that 17% failure rate is the absolute best case scenario on the premium tier.
Right.
If you look at general purpose chatbots, your standard off-the-shelf ChatGPT or Claude running without that specialized legal database grounding, the Stanford researchers found a total disaster zone.
Yeah. Those models hallucinated between 58% and 82% of the time on legal queries.
82%.
If you are using a consumer model for legal research, you are relying on a coin flip, or worse,
Yeah.
as to whether the law you are reading actually exists.
But it is vital we break down what a hallucination actually looks like in practice because the term is slightly misleading.
It is.
It isn't always just a wildly bizarre, obviously fake output. All right, the researchers categorized these failures into different modes. Let's unpack them.
Sure.
The first type is the outright incorrect response. This is the classic fabrication. The AI completely invents a case name, a statute, or makes a blatantly false factual claim about how a court ruled.
That is the easiest to catch, provided you actually try to look the case up. It is pure fiction.
Right.
But the second type of failure is exponentially more dangerous for a practicing attorney. The researchers labeled it a misgrounded response.
Misgrounded.
Yes. In this scenario, the AI describes a legal principle perfectly, it sounds authoritative, and it provides a citation to a real, verifiable case that actually exists in the database.
Okay, but here's the trap. When the lawyer actually pulls up that real cited case and reads it, the text of the ruling does not support the legal claim the AI just made.
Precisely the danger. The AI might cite a landmark case to support a specific motion to dismiss, but if you read the actual judicial opinion, the court ruled the exact opposite way on that specific issue.
Wow.
Or perhaps the AI cited a dissenting opinion, which has no binding legal authority at all, and presented it as the majority rule.
Or sometimes the cited case is just completely irrelevant to the facts at hand, but it happens to share a few keywords with the user's prompt.
Exactly.
This is incredibly pernicious because it completely bypasses a lawyer's initial psychological defenses.
It really does.
I mean, if I ask a tool for a case, and it gives me a real citation, complete with a working blue hyperlink that takes me to a real document, my brain assumes the AI successfully completed its task.
Right. The friction of verifying the underlying logic is so high that the temptation to just trust it is massive.
It creates a false sense of security.
It really does. So we have to ask, why does ARG fail?
Yeah, if the system is literally searching a database of real law, why is it misgrounding the reasoning?
The answer lies in the limitations of the technology's ability to handle multi-layered complexity. The studies show that AI performance degrades sharply in a few highly specific areas.
Okay.
The first major weakness is jurisdictional and geographic complexity. AI models are fairly competent at synthesizing broad federal law or summarizing major U.S. Supreme Court precedents.
Because there's so much data on that.
Exactly. But the architecture falls apart when dealing with highly specific local municipal codes, nuanced state-level administrative rules, or unpublished lower court decisions.
Which, ironically, is where a massive percentage of day-to-day legal practice actually happens. I mean, most lawyers are not arguing before the Supreme Court. They are arguing over a zoning variance in a county court.
Exactly. The AI just lacks the localized context.
And what is the second weakness?
The second major weakness is complex, multi-step reasoning. Simple factual recall works beautifully. If you ask what year was Brown v. Board of Education decided, it gets it right.
Sure.
But if you ask the AI to synthesize a coherent rule from 3 conflicting federal circuit court decisions, and then apply that newly synthesized rule to a highly novel, messy fact pattern involving a client-specific business dispute, the error rate absolutely
You
skyrockets.
just can't make those leaps.
No, the model gets confused by the competing vectors of information and just starts forcing connections that do not exist in reality.
And this leads us to perhaps the most terrifying psychological finding from the Stanford research, the confidence paradox.
The confidence paradox. This is the trap that is catching so many smart people.
So break that down for us.
The research revealed absolutely zero correlation between the AI's expressed confidence in its output and its actual factual accuracy.
None at all.
None. The AI will generate text that sounds equally authoritative, professional, and unyieldingly certain whether it is accurately quoting a landmark Supreme Court ruling or whether it's citing a completely fabricated case that it just hallucinated into existence milliseconds ago.
It doesn't use hedging language. It doesn't say, well, I think this might be true. It says, the law is unequivocally X.
It has the ultimate poker face.
It really does.
And to compound the danger of this paradox, research published in the Harvard Data Science Review investigated what happens when users try to correct the AI.
Oh, this is fascinating.
They found that the second answer an AI gives after a user asks a follow-up question or asks it to refine its logic is statistically often worse than its first attempt.
That is entirely counterintuitive. I mean, if I ask a human associate to clarify a point, they usually hone in on the truth. You're saying if I ask an AI a follow-up question to clarify a muddy legal point, it actually gets less accurate.
Frequently, yes. It is a phenomenon called model drift.
Model drift.
As the conversation lengthens, the AI model can lose its anchor to the original factual prompt. It starts prioritizing conversational flow and trying to appease the user's apparent goal, drifting further from the verified source material.
But crucially, its tone of absolute confidence remains completely intact.
Always.
Here is where it gets really interesting, the profound irony of this entire technological revolution. These systems are being aggressively sold to law firms on the singular promise of saving lawyers time.
Right.
But because of this deeply ingrained 17% hallucination rate, the invisible misgrounding, and the confidence paradox, lawyers are now being forced into a whole new paradigm. They have to meticulously, manually double-check every single output, every single citation, and every single logical leap the AI makes.
It fundamentally shifts the human attorney's burden from original drafting to exhaustive auditing.
And auditing AI output is not a task for a novice.
Not at all. It requires a massive degree of substantive legal knowledge. You have to know the law deeply enough to spot when a highly confident, eloquent machine is subtly misrepresenting the holding of a complex case.
Yeah, a junior associate might not have the experience to spot a hallucinated nuance that a senior partner would catch immediately.
Exactly. So we have to look at the inevitable breaking point.
Let's paint the picture. It is 11 p.m. on a Thursday. The lawyer is exhausted, their kids are asleep. The summary judgment brief is due tomorrow morning.
A classic scenario.
And the AI just generated a beautiful, persuasive 3-paragraph argument with 4 citations that perfectly support their client's position. The friction to go log into Westlaw and read all 4 cases is incredibly high. The friction to just hit copy-paste is 0. What happens when they surrender to the convenience?
What happens is they wake up a few weeks later in front of a federal judge facing severe monetary sanctions, devastating public humiliation in the legal press, and the very real potential loss of their livelihood.
Which isn't theoretical anymore.
No, not at all. This brings us to the dramatic real-world consequences we're seeing sweeping through the courts right now.
The sanctions reckoning. It started as a novelty, but now it is a full-blown crisis.
Between 2024 and 2026, we have witnessed an explosive rise in court sanctions related to artificial intelligence. We now have public records of over 8 attorneys being formally sanctioned in federal courts for AI-related misconduct.
And dozens more currently facing quieter state-bar disciplinary proceedings.
Exactly.
Now, most people vaguely remember the famous Mata v. Avianca case in New York from a few years ago. That was the original ChatGPT incident where the lawyers submitted a brief full of totally bogus cases and it made national news.
Right.
People laughed it off as a one-time anomaly by tech-illiterate lawyers. But that was just the canary in the coal mine. The cases hitting the dockets in 2026 are far more severe and legally complex.
Much more complex.
Let's really dive into the recent Oregon case, Couvret v. Wisnowski.
Couvrette is a massive watershed moment for the industry. It resulted in a record-setting, six-figure combined sanction specifically, $110,204.38, imposed by Magistrate Judge Mark D. Clark against two lawyers.
Over $110,000 in personal sanctions?
Yes.
What exactly were the mechanics of the failure? I mean, how did they end up there?
Well, the attorneys submitted a series of summary judgment briefs that, upon review by opposing counsel and the judge, were found to contain 15 fabricated case citations and 8 non-existent judicial quotes.
The AI had completely invented the case law to artificially support the lawyer's arguments.
Entirely. But the most crucial lesson for the legal community from Couvrette isn't just the sheer volume of the hallucinations. The terrifying precedent is about exactly who the judge held responsible.
Right.
There was an out-of-state lead counsel who actually ran the AI prompts and wrote the brief, but there was also a local counsel in Oregon, a lawyer named Murphy.
And what did Murphy do?
Murphy didn't write the brief. He didn't interact with the AI tool at all. He merely reviewed the final document and, as required by court rules for out-of-state representation, he signed his name to the filing.
And because his signature was on the document, he owned the AI's hallucinations.
The court made the liability standard crystal clear. Signing a document equals total ownership of its contents.
Wow.
Contractual or organizational distance from the actual AI prompt does not distribute, dilute, or reduce your personal liability. If your state bar number is on the bottom of that PDS, you are personally attesting to the factual and legal accuracy of every single word.
That is a terrifying wake-up call for local counsel, or really any senior partner who habitually signs off on work drafted by juniors using AI.
It should keep them up at night.
And Oregon isn't an isolated incident. There's the recent Deneen v. Kochka case down in Arizona.
Yes, in July 2026, the Arizona Court of Appeals issued a scathing ruling highlighting severe citation errors in an appellate brief. This case was a textbook example of the misgrounding we discussed earlier.
So not fake cases.
No, the AI didn't invent fake cases. It cited real cases, but for principles they absolutely did not support. It also included completely incorrect page references, sending the judges on a wild goose chase.
And in the federal system, there was Park v. Parker, also right around July 2026. A federal judge referred an attorney for formal discipline after they submitted a reply brief relying on a non-existent case that had been generated by a cheap, consumer-grade AI model.
What the judiciary is identifying across all these jurisdictions is a behavioral trend that experts are now calling the Gordon-Rees pattern.
Okay, explain the Gordon-Rees pattern for us. Where does that term come from?
It is named after early, high-profile incidents involving a specific firm, but it describes a systemic organizational failure.
How does the pattern work?
The pattern goes like this. A law firm has an embarrassing AI hallucination incident in court. They get caught, they face the judge, and they promise the court they have completely overhauled their internal AI policies and training to ensure it never happens again. And then, a few months later, they have another hallucination incident in a different case.
So they didn't actually fix the root behavioral problem.
Exactly. And courts are now treating these repeat organizational failures with extreme prejudice. A prior incident by anyone in the firm creates a rebuttable presumption in the judge's mind of systemic, willful incompetence at that firm.
It goes from bad to worse fast.
The judicial transition from a simple monetary fine to severe contempt charges, outright case dismissal, and referral to the state bar for disbarment proceedings happens incredibly fast when a firm demonstrates a pattern of unverified AI use.
I have to ask, though, what if the lawyer genuinely just made a mistake?
What do you mean?
Like, what if they were rushing, they relied on a tool they thought was safe, and they just screwed up? Do the judges offer any leniency if you just admit fault?
In theory, yes, but in reality, the cover-up is almost always worse than the crime, and that is what is driving the harshest sanctions.
The cover-up.
In both the Oregon Couvrette case and a very similar AI hallucination case in Nebraska, when the opposing counsel, or the judge, first pointed out that the cited cases likely couldn't be found in any database, the attorneys didn't immediately confess.
Right. They initially misrepresented the origin of the errors.
It is the panic response.
They doubled down.
They doubled down. They tried to blame a junior associate for sloppy research. They tried to brush it off as a weird clerical error with Westlaw. They engaged in days of obfuscation before finally went backed into a corner, admitting that a generative AI tool had drafted the text.
And as every first-year law student knows, you never, ever lie to a federal judge.
Never. The courts in these cases have explicitly noted in their orders that the attorney's subsequent misrepresentations drove the severity of the financial sanctions much more than the original AI hallucination itself.
So failing to verify an AI output violates the ethical duty of competence. But lying to a judge about how a document was created violates the duty of candor to the tribunal. That is a fundamentally more severe ethical breach that strikes at the integrity of the judicial system itself.
Precisely.
Okay, let me throw a wrench in this. Let's say I am a lawyer and I am terrified of these consumer tools making things up. So I go out and I spend serious money. I buy an enterprise premium tool, let's say Thomson Reuters Co-Counsel, which is widely considered top tier.
Okay.
I know Co-Counsel was actually involved in a recent Fifth Circuit sanction case. Does buying the most expensive specialized tier of AI buy you a pass with the judge? Can you say, Your Honor, I use the best tool on the market, it is not my fault?
Absolutely not. The Fifth Circuit incident definitively proved that commercial enterprise AI platforms are not a safe harbor from liability.
Wow.
In that case, the attorney used Co-Counsel alongside VLEX two very expensive, deeply respected, purpose-built legal AI systems. And the system still hallucinated a legal standard.
So the court didn't care what they paid for it?
Not at all. The court's stance is resolute. The product tier you purchase does not determine your verification obligation. The human attorney must independently verify every single output, regardless of whether they used a free app or a tool that cost $10,000 a month.
Okay, so court sanctions are the loud public nightmare. Your name is in the headlines, the judge is yelling at you. But based on our sources, there's a much quieter, arguably more devastating risk lurking behind closed doors when attorneys use the wrong type of AI.
Yes, there is.
I am talking about a mistake that won't get you sanctioned by a judge, but will get you sued for massive malpractice by your own client, and that is the destruction of attorney-client privilege.
This is the invisible minefield.
Let's look at the mechanics of this by breaking down the February 2026 federal court ruling in United States v. Hepner out of the Southern District of New York.
Hepner is arguably the most critical case of the decade for understanding the boundaries of legal privilege in the AI age.
Set the scene for us.
It was a criminal case, and a non-lawyer defendant used a standard consumer-grade AI tool to generate legal strategies, analyze his situation, and draft documents.
Okay.
During discovery, the prosecution wanted access to those AI prompts and outputs. The defendant fought back, trying to claim that his communications with the AI were protected by attorney-client privilege, or at the very least, the work product doctrine, because he was using the tool as a substitute for legal counsel.
The logic makes a twisted kind of sense from a layman's perspective. I mean, he was doing legal work, so it should be protected, right?
Right, but the federal court completely rejected that argument, and their reasoning fundamentally alters how lawyers must view AI.
What did they rule?
The court ruled definitively that communications with a public generative AI platform are not protected by privilege.
Walk us through the technical why behind that ruling. Why does the technology break the privilege?
It all comes down to the fundamental data architecture of public generative AI platforms. When you type a prompt into a consumer tool, like the free public versions of ChatGPT, Anthropic's Claude, or Microsoft Copilot, you are transmitting that data to a server controlled by a massive tech corporation.
Okay.
Under traditional legal principles, voluntary disclosure of privileged, confidential communication to an unauthorized third party instantly and permanently waives the privilege.
Because you aren't keeping it a secret anymore, you are sharing it with OpenAI or Google.
Exactly. In the eyes of the law, entering client data into a public chatbot is the functional equivalent of CCing a random stranger on a highly confidential email to your client.
That is a disaster.
But it gets worse. The court noted that these public AI tools don't just process the data and forget it, they actively retain user inputs to train their future models.
This is the mechanism called self-learning or continuous training.
Yes. The AI company scrapes your prompts, breaks them down into weights and biases, and uses your residual data to make the machine smarter for the next user.
So, using a free public AI for sensitive client data is basically like standing in a crowded coffee shop, shouting your client's deepest financial secrets to a stranger who has a photographic memory and who makes their living talking to other people.
That is a phenomenal analogy.
Yeah.
Because the stranger will talk to other people. This isn't just a theoretical law school exam hypothetical. It is a massive operational risk.
Give me a scenario.
Imagine a scenario where a senior partner inputs a client's highly confidential, unannounced mergers and acquisitions negotiation strategy into a public AI to quickly generate an executive summary.
Okay.
The AI processes the data, gives the summary, but it retains the underlying strategy in its training set. A week later, it is technologically possible that an attorney representing a competitor could log into the exact same public tool, ask a broadly related question about image trends in that specific industry.
And the AI could actively regurgitate parts of your client's confidential strategy as part of its helpful response.
Yes, the AI just breached your client's confidentiality to help their competitor.
That is a career-ending malpractice lawsuit waiting to happen.
Which is exactly why we must be clear. General-purpose models operating under standard consumer terms of service are fundamentally inherently unsafe for any privileged legal deliverables.
You simply cannot use consumer-grade AI for client work, period.
Period. To protect privilege, you must operate exclusively under strict enterprise-level software agreements that provide legally binding guarantees of zero data retention, zero model training on your inputs, and secure data residency.
And this exact fear, this massive liability black hole regarding confidentiality and competence, is exactly why the American Bar Association and state bars across the entire country have radically rewritten their ethical rulebooks for 2026. We are now operating in a dense regulatory web.
The regulatory landscape had to shift rapidly to address these specific technological failures. The national anchor for all of this is ABA Formal Opinion 512, which was issued back in July 2024.
Right.
It serves as the primary framework for translating the existing model rules of professional conduct into the generative AI era.
Let's break down the core components of ABA 512, because this is the survival playbook every single lawyer needs to memorize. Let's start with Rule 1.1, competence.
Rule 1.1 establishes the duty of technological competence. In the context of AI, the ABA states that a lawyer must have a reasonable current understanding of how an AI tool works, what its capabilities are, and crucially, its limitations like the hallucination rates we discussed.
So you cannot blindly delegate analytical legal tasks to a machine.
No, you have a non-delegable ethical duty to independently verify the output. Uncritical reliance on AI is a direct breach of professional competence.
Moving to Rule 1.6, confidentiality.
This rule essentially codifies the Heppner ruling at the ethical level. You must protect client information from unauthorized disclosure. Practically, this means you, as the attorney, must conduct active due diligence on your AI vendor's data security architecture.
You must ensure they have zero data retention policies.
Yes. If you are using a tool that is self-learning, one that trains its model on user inputs, the ABA dictates that you must obtain specific, informed client consent before entering any confidential data into that system.
And they explicitly note that hiding standard boilerplate language in a 20-page initial engagement letter is not sufficient informed consent.
No, it has to be clear and specific.
Then there is Rule 5.3, supervising non-lawyers. This is an interesting categorization.
It is. The ABA and state bars have decided to explicitly treat AI software as a non-lawyer assistant.
Oh, wow.
Therefore, partners and managing attorneys are ethically responsible for the AI's work product in the exact same way they are responsible for a paralegal's work.
You must supervise the machine.
Yes, the supervisory duty remains with the human carrying the license. It cannot be delegated to the software's algorithm.
Rule 3.3, candor to the tribunal.
This addresses the court sanctions we discussed with the Gordon-Rees pattern. You have an absolute, non-delegable duty to verify the factual and legal accuracy of all citations, all quotations, and all substantive arguments before submitting a document to a judge.
So submitting a hallucinated citation, even accidentally, is a violation of this duty.
Correct.
And finally, Rule 1.5, fees. I want to spend a minute here because this one is fascinating. It actively hits the law firm's wallet and upends the entire economic model of the legal industry.
It absolutely attacks the traditional billable hour model. Rule 1.5 states that a lawyer can only bill a client for actual time spent working on a matter.
Okay, so if an autonomous AI agent allows you to thoroughly review and redline a complex commercial lease in 1 hour, whereas it used to take you 5 hours manually, you can only bill the client for that 1 hour.
Exactly. You cannot double bill, and you cannot charge the client a premium based on the perceived value of the 4 hours you saved by using the AI.
So law firms that survive entirely on leveraging thousands of associate billable hours are facing a massive revenue cliff if they adopt AI.
But a massive efficiency disadvantage if they don't. It is an existential economic crisis for traditional firms.
Wow.
Furthermore, the ABA rule explicitly states you cannot bill clients for the time you spend learning how to use a new AI tool. Your training time is your own problem.
And critically, the baseline software subscription costs for these massive enterprise AI platforms must generally be treated as firm overhead, just like your electricity bill or your office rent.
Yes, you cannot pass those massive subscription costs through as direct line item client expenses unless it is a very specific standalone per-use tool.
Yeah.
And you get explicit client agreement beforehand.
Okay, so that is the national ABA framework. But the ABA just issues guidelines. The individual state bars are the ones that actually suspend licenses, and they have their own specific, wildly different nuances.
Yes, the state level is where the rubber meets the road with actual enforcement, and the fragmentation is a nightmare for multi-state practitioners.
Florida Bar Ethics Opinion 24-1 was an early aggressive leader, right?
It was. Florida requires strict verification of all AI output, but they added a unique, heavy focus on marketing. If a Florida law firm uses an AI chatbot on their public website to field initial client inquiries, the bar requires a highly visible disclaimer telling the user they're interacting with a machine, not a human lawyer.
Makes sense.
Florida also strictly enforces a 30-day waiting period on targeted solicitation after a major incident, preventing AI from being used to instantly scrape news sites and auto-email victims of a disaster.
What about Texas? I read they took a very different, almost aggressive procedural approach.
Texas Professional Ethics Committee Opinion 705 mandates absolute human review of all AI-generated filings to prevent fake citations. But the real teeth are in Texas. Local Rule 7.2F.
The negative certificate.
Yes. This rule brilliantly flips the burden of proof. It treats the absence of a disclosure as a negative certification, meaning if you file a brief in Texas and you don't affirmatively state you used AI, you are legally certifying to the court that you either did not use AI at all or that a human fully and comprehensively verified every single word.
So if a hallucination is later found in that document, you cannot claim ignorance.
Not a chance. Texas also enacted incredibly strict advertising rules, like a 10-day ad filing window for bar review and a mandatory 4-year record retention requirement for all AI-assisted marketing materials.
And New York. They're pushing for actual sworn oaths, right?
Yes, New York is pushing hard on procedural hurdles to force compliance. Proposed CPLR Rule 2107, which is also known in the legislature as Assembly Bill 8546, would require attorneys to file a formally sworn affidavit disclosing their use of generative AI and certifying under oath that human verification occurred whenever AI is used to draft formal court papers.
Swearing an affidavit under penalty of perjury every single time you use an AI tool to help write a motion, that is intense friction.
It really is.
And outside of the state bars, we have the federal judges themselves. You mentioned earlier there are over 300 federal judges who have just bypassed the system and issued their own individual standing orders on AI.
Yep.
For those not familiar, a standing order is basically the judge's personal rulebook for how you must behave in their specific courtroom. Navigating 300 different personal rulebooks is a logistical nightmare.
It is a massive compliance headache for litigators. These 300-plus standing orders generally fall into 3 distinct categories.
Okay, let's go through them.
The first is the blanket disclosure approach. This is the most restrictive, and about 35% of the standing orders fall into this bucket. These judges require you to affirmatively disclose whether AI was used in preparing any part of the filing, regardless of whether you verify the output or not.
Wait, so even if I just used an AI as a brainstorming partner to bounce a legal theory off of, but I wrote the entire brief myself from scratch, I still have to disclose it to the judge?
Under a blanket disclosure order, yes. Any involvement triggers the disclosure requirement.
That seems broad.
It is. The second category is conditional disclosure, which makes up the majority, about 50% of the orders. Here, the judge takes a more pragmatic approach. You only have to disclose the use of AI if AI-generated text was included in the final document without full, independent human verification, or if the AI was relied upon for foundational legal research that you didn't double-check.
And the third category?
The responsibility-based approach. Only about 15% of judges use this. These judges don't require a specific, separate AI disclosure at all. They simply issue a standing order reaffirming that counsel is 100% responsible for the accuracy of all filings, regardless of what tools, human or machine, they use to generate them.
They argue that Rule 11 of the Federal Rules of Civil Procedure already requires attorneys to certify their filings are accurate, so a special AI rule is redundant.
Exactly. They are just making it explicitly clear that they will aggressively enforce Rule 11 if an AI hallucinates in their courtroom.
But there is a huge constitutional conflict brewing between the state Supreme Courts and these federal judges, right?
Yes, a significant and very messy conflict.
How so?
Well, for example, the Illinois and New Jersey Supreme Courts have issued formal guidance stating that Disclosure of AI use should not be required in standard pleadings. Their legal logic is actually very compelling. They argue that forcing an attorney to disclose exactly how they used AI is essentially forcing them to volunteer their internal work product and their mental strategy to opposing counsel.
And under the adversarial system, you do not owe your opponent a window into your brainstorming process.
Exactly.
So, if I am a litigator, I am caught in an impossible bind. I have a state Supreme Court telling me not to disclose my AI use to protect my client's strategy and work product, but I have a federal judge threatening me with sanctions if I don't disclose it.
It is the ultimate jurisdictional catch-22.
So what does this all mean practically? If you're a litigator navigating this absolute minefield in 2026, what is the actual on-the-ground rule of thumb to keep your license?
The universal defensive rule of thumb for 2026 litigators is simple. Default to disclosure.
When in doubt, disclose.
Yes. The empirical data across the country is clear. No attorney has ever been sanctioned by a court for over-disclosing their AI use. But we know for a fact that at least 8 attorneys have been sanctioned, fined, and publicly humiliated for under-disclosing.
The risk profile is entirely one-directional.
It is. Every firm should have heavily vetted template certification language ready to append to every single filing.
Okay, so we've established that the ethics rules are strict, the judicial penalties are severe, and the underlying technology is both incredibly powerful and inherently dangerous.
Correct.
So what does this all mean for the actual software buyers? If I am an in-house counsel or if I am a managing partner at a mid-sized firm trying to modernize, how do I navigate this landscape to find a tool that actually works, protects my data, and won't get me disbarred?
That brings us to the most critical strategic decision a legal professional will make in 2026.
Choosing the tool.
Right. The single most expensive mistake you can make right now is buying the wrong category of software for your specific daily workload, simply because a vendor has a massive billboard or a shiny brand name. You have to divorce the marketing from the utility. You must buy the category, not the brand.
Let's walk through this 2026 vendor landscape. We've grouped the market into 4 main categories. Let's start with Category 1.
Category 1 is purpose-built in-house suites, which the industry often calls workbenches.
Workbenches.
Yes. These are holistic environments designed for drafting, review, redlining, and matter management, all housed in one secure place. And critically, they are priced for small to mid-sized teams.
If I am a solo general counsel at a tech startup, who are the players I should be looking at here?
GCAI is a dominant top pick for the solo generalist. It runs about $500 per seat per month. It is incredibly agile and great for triaging the wide variety of chaotic daily issues an in-house lawyer faces.
So jumping from task to task.
Exactly. You might use it for a nuanced employment law question at 9 a.m., analyzing a vendor NDA at 10 a.m., and drafting a strategic board memo after lunch. It handles context switching beautifully.
I've also heard a lot about Vaquill AI in this space.
Yes, Vaquill AI is the major disruptor in Category 1, largely because it is priced very aggressively at just $99 per user per month.
$99? That's cheap.
It is. And it's built heavily around maintaining end-to-end matter context, meaning it remembers the whole history of a specific deal, not just the single document you are looking at.
Oh, that's smart.
What makes Vaquill truly unique is that it offers a native open-source Microsoft Word add-in with no extra implementation fees. Plus, it hosts its own massive proprietary database, over 4.8 million sections of U.S. code, the code of federal regulations, and 50 state statutes accessible via API. It is a remarkably powerful, self-contained workbench for a lean, budget-conscious team.
But if your job isn't general triage and you're just grinding through vendor agreements all day, a generalist tool is going to frustrate you. You need a dedicated engine.
Right, which is Category 2.
Dedicated contract review. This is for teams doing heavy, high-volume transactional work.
Precisely. If your entire week consists of redlining NDAs and MSAs against a rigid corporate playbook, which, for our non-lawyer listeners, means checking a proposed contract against your company's master list of terms you will and will not legally accept, you need a specialist tool.
Who are the leaders here?
Ivo and Legalon are the current leaders for sheer volume review. They can churn through thousands of playbook checks incredibly fast, flagging deviations with high accuracy.
And then there's Spellbook.
Spellbook.
Spellbook is fascinating because of where it lives. It lives entirely inside Microsoft Word, right?
That is its killer feature. It costs about $500 a seat, And it is absolutely beloved by transactional lawyers because they never have to change their behavior.
They don't have to upload documents to a third-party web dashboard.
Exactly. The AI drafts new clauses and executes complex red lines right inside the Word document where the lawyer already spends 10 hours a day. It removes the friction of adoption.
Moving up the scale, we have Category 3, firm-side AI platforms. These are the absolute giants of the industry.
These are deep, highly complex agentic document platforms built explicitly for the AmLaw 100, the top 100 highest-grossing law firms in the country, and massive multinational corporate legal departments.
Harvey is the big one here.
Harvey is the undeniable gravity well in this category. It recently hit an $11 billion valuation. It boasts massive exclusive data integrations with tools like LexisNexis, and it excels at deep, complex, multi-document agentic work.
It can analyze a data room with 10,000 documents.
Yes, but it has a very steep barrier to entry, often starting at $1,200 or more per user per month, with high minimum seat counts that lock out smaller firms entirely.
And Legora is the other heavyweight fighting Harvey in Category 3.
Yes, Legora, which was formerly known as Leia, raised a massive $600 million Series D round in 2026, pushing its valuation to $5.6 billion. They run slightly cheaper, between $300 and $800 a seat.
What's their differentiator?
Its major differentiator is collaborative AI, where dozens of lawyers across different time zones can work on the same massive litigation matter simultaneously with the AI updating context for everyone.
But there are some downsides reported, right?
Yes. It is important to note that enterprise users have consistently reported that its analytical quality drops off significantly when processing single documents that run past 200 pages. There have also been concerning reports of legal hold retention gaps during their initial enterprise rollouts, which is a massive red flag for litigators dealing with spoliation of evidence.
Good to know. Finally, Category 4 is legal research with AI. This feels like the most mature segment.
It is, because it's essentially traditional primary law research upgraded with a generative AI interface. The major players here are the legacy titans.
Counsel.
You have Counsel, which is deeply tied to the Thomson Reuters and Westlaw ecosystem, running anywhere from $225 to over $400 a month, depending on your existing Westlaw package.
And Lexis Plus AI.
Right, which has recently rebranded its core engine as Protégé. Protégé is highly regarded because it grounds its answers in the proprietary LexisNexis library and utilizes Shepard's validation, which is the gold standard system for verifying whether a case is still good law or if it has been overturned.
But wait, when we are looking at these vendors, especially the startups in categories 1 and 2, we have to talk about vendor staying power.
We really do.
You can't just buy a tool, upload your entire firm's sensitive historical data, and hope the startup still exists in 6 months. Let's talk about the cautionary tale of Robin AI.
Robin AI is the harsh reality check that nobody in the legal tech echo chamber wanted to acknowledge. They were a massive pioneer. They built a compelling product combining AI initial review with human experts in the loop for complex contract analysis.
They had serious market traction.
And a great reputation. But in late 2025, a planned $50 million funding round completely collapsed and failed to close.
And what happens when a venture-backed AI startup suddenly runs out of runway?
Immediate, massive turmoil. They had to lay off roughly 50 people overnight. Their managed services division was hastily sold off for parts, and a significant portion of their core engineering team was absorbed by Microsoft in a talent acquisition.
Wow.
The online forum chatter among lawyers shifted overnight from praising their new product features to panicked warnings about a looming legal AI bubble.
So if I am a buyer in 2026, how does the Robin AI collapse change my due diligence process?
It means that assessing vendor staying power is now a mandatory, non-negotiable part of your procurement due diligence. You must demand to see their financial runway.
You must secure explicit data export rights in your contract, guaranteeing that if they fold tomorrow, you get your client data back in a usable format immediately.
Exactly. And you need clear termination terms in the master services agreement.
Yeah.
You cannot afford to have your firm's data trapped in the servers of a bankrupt company.
Now, I know what a lot of listeners are thinking because we hear this objection all the time. Why can't I just use ChatGPT Business or Microsoft Copilot?
Right.
I mean, my company already pays $30 a month for it. It is safe. It is private. Why on earth am I going to pay $500 a month for a specialized tool like Spellbook or GCAI?
It is the most common question. And the answer is that general-purpose models, even the enterprise versions that don't train on your data, are fundamentally ungrounded for the mechanical reality of legal work.
We already discussed the massive 58 to 82% hallucination rates on legal reasoning.
But beyond the accuracy problem, they completely lack workflow integration. ChatGPT doesn't give you a native Microsoft Word redline. It gives you a chat summary of suggested text edits in a browser window.
You cannot take a bulleted chat summary and send it to opposing counsel as a formal track changes document.
Right, in contract law, the redline document is the entire deliverable. If the tool can't produce a redline, it is not actually doing the work.
Exactly. Furthermore, general models lack persistent matter context.
They treat every chat as a blank slate. They don't automatically keep a master service agreement, its 3 rounds of red lines, and its eventual renewal all linked together in a secure, privileged environment.
Let me push back from a different angle, though. Let's say I'm a lean, two-person in-house legal department. I have budget, and I hear that Harvey has an $11 billion valuation, and all the top AmLaw 100 firms are using it. Shouldn't I just buy the absolute best, most powerful tool on the market to give my small team an edge?
Buying Harvey for a 2-person in-house team is like buying a Formula One race car to drive your kids to soccer practice. It is a massive misallocation of resources, and it will probably crash.
I love that analogy. You don't have a pit crew to maintain the F1 car, and you are just trying to navigate neighborhood speed bumps.
Exactly. You need to price your software to your real volume and your real operational needs. Tools like Harvey and Legora are custom-built for massive, multi-tiered enterprise workflows spanning hundreds of lawyers.
A solo general counsel needs agility, range, and triage capability, which is exactly why a $99 or $500 workbench fits perfectly.
In software procurement, functional fit beats raw horsepower at a small scale every single time.
Okay, so having the right tool in the right category at the right price is clearly only half the battle. The other half is human behavior.
Yes, it is exactly how the attorney interacts with the software on a daily basis.
Which leads us to the operational standard for 2026. Let's open the playbook.
The absolute mandatory operational standard across the entire legal industry in 2026 is human in the loop, commonly initialized as HITL.
Let's define the acronyms for the audience, because there are 3 distinct tiers of human oversight in AI, and only one of them will keep you from getting disbarred.
Right. Let's start with the gold standard, human in the loop, or HITL. This protocol requires explicit, documented human review and active approval of every single AI-generated output before any action is taken.
So before a draft is emailed to a client, before a red line is sent to opposing counsel, or before a brief is filed with a court, a human must verify it.
This is the only operational model that satisfies the ABA's professional responsibility standards.
Then there is the middle ground, human on the loop, or HOTL.
HTL allows the AI software to act semi-autonomously, while a human passively monitors the operations on a dashboard, retaining the ability to intervene or hit a kill switch if they see something going wrong.
So this model is highly useful for massive, continuous monitoring tasks.
Like scanning a database of 10,000 legacy contracts to flag which ones need updating due to a sudden regulatory change. It is great for internal audits.
But it is ethically unacceptable for any workflow involving direct client representation or the execution of binding legal commitments.
Exactly. You cannot let the AI automatically send out contract amendments.
And finally, the disaster zone, human out of the loop, or HUTL.
HUTL removes human oversight entirely. The AI operates, reasons, and executes decisions completely autonomously.
In the practice of law, utilizing a HUTL system for substantive legal work is strictly prohibited. It is an immediate, egregious ethics violation of the duty of competence.
Absolutely.
So how do we actually operationalize human in the loop in a busy law firm? GCAI teaches a 3-step ethics framework that has basically become the de facto industry standard. The steps are prompt, verify, audit.
Let's break down step 1, prompt. Most people think prompting is just about getting a good, useful answer. But in law, prompting is about establishing an ethical defense.
Okay, how so?
When you prompt the AI, you must provide deep, specific context. You must intentionally force the AI to ask you clarifying questions before it starts generating text. And most importantly, you must explicitly give the AI a psychological out.
A psychological out.
You literally type into the prompt window. If you do not know the answer or if the case law is ambiguous, you must say, I don't know.
I want to highlight the mechanics of that. Because an LLM is a prediction engine trying to satisfy your query, you have to give it explicit permission to be ignorant. Otherwise, it will bend over backwards and invent a hallucination just to give you the answer it thinks you want to hear.
Precisely the mechanism. You change its prediction parameters by rewarding it for admitting ignorance. You also need to actively ask the AI to identify weaknesses in its own reasoning. This combats the machine's inherent confirmation bias.
And obviously, if you are using a tool that isn't fully enterprise secured, you must meticulously anonymize all confidential client information before you hit enter.
Of course.
Step 2, verify. This is the heavy lifting where the actual lawyering happens.
Verification is non-negotiable. You must manually check every single citation the AI provides against primary authoritative sources. That means logging into Westlaw, Lexis, or Vaquill's database and reading the case. You must verify every assertion of fact.
And critically, you must read the case to verify that the judicial reasoning actually supports the proposition the AI stated in order to catch those invisible, misgrounded hallucinations.
Yes.
What are the specific red flags a lawyer should be looking for during this verification process?
There are 6 major algorithmic red flags that indicate the AI is likely hallucinating. 1, circular reasoning, where the AI uses its own generated premise as proof of its conclusion.
Got it.
2, two-way response that perfectly uncritically mirrors your prompt back to you. It is essentially just violently agreeing with your underlying premise rather than objectively researching it. 3, extreme confidence, with absolutely no caveats, nuance, or dissenting opinions mentioned. Law is rarely absolute.
Okay, 4.
4, citations provided without working hyperlinks, or citations that use slightly bizarre formatting that you simply cannot locate when you search a primary database.
5.
5, high context window usage.
Let's explain that one. What does high context window usage mean?
The context window is essentially the AI's short-term memory for a single conversation. If you give the AI a very short, simple prompt, and it spits back a massive, rambling, overly complex answer that seems to lose focus, it means the model is struggling to find semantic grounding. It is grasping for tokens to fill the space because it doesn't actually know the answer.
And 6, the biggest red flag of all the AI makes a bold legal claim but provides absolutely no citations at all.
If there are no citations, it is just a creative writing exercise.
Okay, step 3 of the framework audit.
Auditing is entirely about maintaining a defensible chronological paper trail. You must utilize software that automatically logs the AI's initial proposals, logs the human attorney's subsequent modifications and corrections, and logs the final, approved version of the document.
This creates an immutable compliance record for regulatory requirements, and it provides absolutely vital evidence of competent active supervision if you ever face a malpractice defense or a show cause order from an angry judge.
Exactly.
To make this practical for a firm of 50 or 100 lawyers, you can't just rely on good intentions. You need a formalized policy. Let's talk about the traffic light system for internal AI use policies.
Every single law firm operating in 2026 needs a one-page, easily digestible AI use policy built on a traffic light framework.
Let's run through it. Red?
Red means prohibited. This category includes entering any client info into consumer-grade AI, submitting unverified court filings, or billing clients for hours the AI saved you. These are zero-tolerance firing offenses.
Yellow?
Yellow means oversight required. This covers using enterprise tools for initial legal research, drafting internal memos, or conducting first-pass contract redlining. A designated licensed lawyer must review the output before it ever leaves the internal team.
Green?
Green means standard use. This represents low-risk tasks, like using AI to summarize a massive, publicly available government regulatory report or brainstorming high-level marketing copy for the firm's website.
And if a firm is looking to buy one of these enterprise tools, how do they actually test it? We all know a slick 20-minute sales demo orchestrated by a vendor doesn't mean anything. How do you run a real, rigorous 30-day pilot?
The cardinal rule is you never, ever trust a vendor's preloaded sample document.
Never.
You take a known complex NDA or MSA that your firm has manually redlined 100 times, and you run that document through the tool live.
You also rigorously time how long it takes to manually tag a playbook clause into the system, because the massive setup time required to teach the AI your specific rules is a hidden, sunk cost that vendors conveniently never advertise.
They never mention that part.
What about the security review during the pilot?
Before the pilot even begins, you demand their SOC2 Type 2 compliance report.
For those who aren't in IT procurement, a SOC2 Type 2 report isn't just a basic security checklist a startup can fill out in an afternoon.
No, it is an independent, grueling audit where a third-party security firm literally monitors a software company for 6 to 12 months to prove that they actually follow their own data security rules in practice, not just on paper.
If a vendor doesn't have it, they are basically asking you to trust them on blind faith. You also demand a full sub-processor list to see who else is touching your data. If they hesitate on either, walk away immediately.
Absolutely.
And what about the contract itself?
This is the most important part. You demand a strict, unequivocal training exclusion clause in the master services agreement. It must be a legally binding clause in the written contract, not just a vague promise in an FAQ section on their marketing website.
If they refuse to put it in the MSA, you must legally assume they are training their future models on your highly confidential client data.
That is the only safe assumption.
The ultimate takeaway for you, the listener, whether you are a first-year associate or a managing partner, is this: AI is an incredibly powerful, tireless digital teammate. It can process information and recognize patterns at a scale and speed that is genuinely superhuman. But you are the supervising partner.
Yes, you carry the state bar license, you carry the professional liability insurance.
The AI algorithm cannot go to jail, and the AI cannot be disbarred. You can.
The technology has absolutely revolutionized the speed at which lawyers can produce text, but it has not changed the professional standard of accuracy one iota. The burden of judgment, the requirement for ethical fidelity, remains entirely human.
And that wraps up an incredible amount of deep intelligence on the reality of the 2026 legal landscape. But we can't let you go without a final provocative thought to chew on as you head back to your practice.
We've spent all this time today focusing on how human lawyers must meticulously verify AI outputs to protect themselves and their clients. But consider the very near future of these autonomous agentic systems.
What happens when an autonomous agent representing your firm starts negotiating a complex commercial contract directly against an autonomous agent representing the counterparty?
If both AI systems suffer from the confidence paradox we discussed, and they both begin hallucinating contradictory legal precedents in order to aggressively win a point for their respective clients,
How does a human mediator or a federal judge even begin to unravel a complex legal argument that was invented entirely by competing machines?
is going to be chaos.
That is a wild dystopian scenario, but honestly, based on the velocity of everything we've seen today, it is probably already happening in a server farm somewhere right now, just waiting to end up on a court docket. We want to thank you for joining us on the Data Genius podcast today. If you found this deep dive valuable and want to help us keep bringing you this level of analysis, please support the show by taking 3 quick actions. Like this episode, leave a comment down below sharing your thoughts, and please subscribe for future episodes. Until next time, keep your prompts sharp, your citations verified, and never let the machine have the last word. Stay brilliant.